Hello, this is Matt on the Moon Family Sedan channel, and I must apologize for the grotesque image on your screen right here. But I'll still give credit to XRP community Mac Attack XRP for publishing this. I did get a good laugh out of it. Is this ever going to become real life? I don't know. You guys let me know. But what I want to share with you in this video, as we wait for the conclusion of the SEC v. Ripple case, or at least, at a minimum, Judge Torres' decision, because frankly this thing could go to jury trial. But as we wait for all of that, Attorney John Deaton has shared some very interesting information. He shared what he believes would be the 5 best outcomes in the SEC v. Ripple lawsuit. And it was also interesting to state, and I'll even tell you here, this one of the things that I thought was most positive, I'll tell you right here at the outset of the video, is that he thinks it's very likely that Judge Torres, regardless of how she rules on various aspects of the case, even if the SEC wins, Attorney Deaton thinks that Judge Torres is going to write up an opinion regarding secondary sales of XRP. And so I keep on banging this drum, this idea that, and I've been said it so many times recently, so sorry if I sound like a dead horse, but repeating it like beating the dead horse, whatever. However that thing goes, you got the cut of my jib. Regardless, I think it's important to understand that even if Ripple loses, what matters most to us as XRP holders is that there is a path forward for XRP in the United States. What matters to us here in the United States, but global markets are going to react. Even those market participants outside, it's going to scare them if there's bad news on that front here, because what also might it mean for any other altcoin? So, before going further, though, I do want to be clear. I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so here you have a very well-known individual in the world of crypto, the Wolf of All Streets. This is Scott Melker with 888,000 followers. He tweeted out the other day, this is the March 29th. He said, "Imagine if the SEC loses to Ripple in court. Just imagine." And today, Attorney John Deaton did just that. Just 5 hours ago, roughly, Attorney John Deaton tweeted out this thread where he shares, possible scenarios, including the 5 best outcomes. And so here's what he wrote. Imagined XRP outcomes. Best outcome. Outright win for Ripple with the judge smacking the SEC for gross overreach and behavior in the case. And then in parentheses, he writes, Judge Netburn has commented SEC lawyers are hypocrites, lack faithful allegiance to the law, and only care about winning the next argument. Yeah, and so that's, honestly, off the top of my head, I think probably my favorite thing that I've seen from either Judge Netburn or Judge Torres in this point, because it was just absolute scorn against the SEC from Judge Netburn in this case. And you know that Judge Netburn and Judge Torres were obviously talking to each other. I know that because I saw at least one attorney within the XRP community. I don't know if it was Attorney Hogan, I can't recall off the top of my head. But I remember one of the attorneys, well-known within our community, was noting, well, yeah, they'd probably be, to whatever degree, having communication, whether it's sitting down at lunch and talking about this stuff, whatever it is. So the fact that Judge Netburn was so vocal and so scornful against them, and rightfully so, makes you kind of wonder, what might Judge Torres be thinking? Because Judge Torres is the one that's coming down with the ultimate decision here, and whether or not to bring this to trial, because that's always a possibility, jury trial. But whereas, Judge Netburn, she's just a magistrate judge, or as I call it, because I don't have a legal background, a helper judge, because that's what it's what there's such a caseload when it came to all the discovery stuff. The helper judge, Judge Netburn, was working through this, but still, for her to come to those conclusions, it's interesting. And then there was the second best. John Deaton wrote, for the second best possible outcome, Judge rules Ripple offered XRP as an investment contract, also known as security, early in the XRP ecosystem on a few specific instances, i.e. the brochure sent to 100 potential investors in 2014. But XRP itself is not a security, and ongoing and secondary sales are not securities. And then that's actually, it was, I don't know, a day or two ago probably, I was actually talking about just that. And it's kind of obscure. I don't know how many people are familiar with the brochures incident, but yeah, back in 2014, Ripple was handing out these brochures. And, it's not that they were trying to sell XRP to retail investors or anything like that, But the judge is allowed to come to any sort of judge-style conclusion she wants to. So in theory, could she decide that that was something that was illegal? She could choose that. I don't know if it's probable. I don't know if it's going to happen, but it could. But this is just one example where, Ripple could lose on that single point, but there can still be a very real, very viable path forward for XRP. And then here's the third best outcome from John Deaton. He says, judge denies both the SEC and Ripple's motion for summary judgment and states that a jury must decide disputed facts, and we have the status quo for another year. But the judge makes clear XRP is simply software code and that secondary sales are not securities. Yes, now that I would still be thrilled about. As an XRP holder, I'd be equally thrilled, or close to equally thrilled, for any of those three. As long as there's a path forward, I'd be pretty happy about it. The more obvious the one, the better, I tend to think. But, the question remains, would that be enough for cryptocurrency exchanges to relist XRP? Now, I think the answer, it should be yes. I feel very comfortable saying it should be yes. Is that what's probable? Oh, I sure as hell hope so. It might be. But I still feel like, a platform like Coinbase, if you just look at previous behavior, I could be wrong on this, but I don't get the feeling that they'd be the first to jump on board to relist. But others may jump on, but even if that's the case, don't forget that XRP went to almost $4 back in the beginning part of 2018, and Coinbase did not have XRP listed. It's not like we need Coinbase for XRP to have a run like that. And then here's the fourth best outcome. John Deaton writes, judge grants the SEC summary judgment versus Ripple for both past and present sales of XRP as an investment contract, but the judge makes clear her ruling has nothing to do with secondary sales of XRP. Ripple appeals the case, and we have the status quo for years. And again, so in a situation like that, it does make you wonder, even if the judge provides that type of clarity, which I sure as hell hope would be the case, it seems probable even, would that be enough for exchanges? So we'd still be left there. And then here's the fifth case, which is the worst case out of the ones that he lists here. Attorney Deaton says, the judge grants summary judgment in favor of the SEC like the judge did in Library, but also makes no comment regarding the token itself or secondary sales. I would then attempt to do what I did in Library at a hearing on damages regarding secondary sales. Yeah, so I'm sure you'll recall that I think it was the beginning part of November when that ruling in the Library case came down that Library had lost. Now it's a completely different case, completely different arguments made than what's happened in the Ripple case. So I don't think that case is some sort of indication that, Judge Torres is going to have some terrible, awful rulings, the same way for Ripple or XRP specifically. But if that happens, Attorney John Deaton says he's going to do what he did in the Library case. So when it came to the remedies portion, he ended up filing an amicus and did end up, he was in court for the remedies portion. So I think that was at the end of January this year. And it was impactful, very positive, actually, because when it came to the remedies portion, the judge has articulated that when he writes up his ruling, which is not public to this point, when it's written up, he has stated in court, it's on record, it'll be in the transcript, that secondary markets are not going to be included in part of this. That's a major win. I feel terrible for Library and Jeremy Kauffman, but that's a major win for anybody that wants the LBC credit token, the LBC token to continue to exist. So, you could see something like that here, even if it, God, I hope we don't have to go through, because then it's months getting to the point probably where, where you get to the remedies portion, and then it's a question mark, how does Judge Torres respond then? But even if that happened, that could still be a major win too. It still could be. So even in a worst case scenario, out of these five possibilities anyway, even that would still have potential to be really good in the end, but it could lead to a couple of months of complete market chaos on a global scale. And I think Judge Torres understands her decision is going to cause a global reaction on basically every country on the entire planet except for like North Korea. Everywhere else though, yeah. And then Attorney Deaton also wrote, I've already went on record to say a few things. One, Judge Torres will deny the SEC's motion for summary judgment against Brad Garlinghouse and Chris Larson. The most the SEC can hope for is for the judge to say it's up to a jury to decide whether the two executives were reckless. It's more likely the judge grants judgment in favor of the two executives because no reasonable jury could find them reckless. And then parentheses, he writes, USGAO calls XRP virtual currency in 2014, FinCEN, same in 2015, FSOC, same in 2019, MoneyGram, SEC staff could own XRP until 2019, a Hinman speech, etc. And he then wrote, I believe Judge Torres will comment regarding secondary sales and regarding the token itself. XRP holders' amicus brief and 3,500 affidavits are a big deal. Spin the Bits, Tapjets, and all the other amicus briefs are a big deal. The judge knows the public interest at stake. Yeah, and so that's why I've said everybody that has responded in any capacity has been an important and crucial part of this process. You know, it's easy to feel like when you're one person, it's like, what do I matter? No, it all matters. It all adds up. All of it adds up. And you're talking about, so not just roughly 76,000 XRP holders that Attorney Deaton represents, but 3,500 sworn affidavits. Now, that's gigantic. I've never heard of such a thing like this. And then you have firms coming and being like, whoa, if there's a negative ruling having to do with XRP here, you know, we're Spin the Bits or we're Tapjets, pick your company. This would very negatively impact us, which isn't remotely reasonable or fair. The judge is aware of this, and she's coming in from an unbiased perspective. How could she not do what's right, even if she finds Ripple did something illegal? And that's an if. And then Attorney Deaton wraps this up by saying, if you could only pick one side to get an outright victory, nothing in the middle, you must favor Ripple. The SEC's theory in the case is just too overbroad and outstretched for an outright victory. The issue is just how deep does Judge Torres go in to find specific offers/sales? Well, good question, because it's a very good question, actually, because the SEC didn't cite any specific transactions. They just went after everything, which is an insane way to approach this. I've never heard of such a thing. And fine, yeah, I don't have a legal background, so why would he? But what I mean is, over the 2+ years I've been covering this stuff, there haven't been any examples brought up where anything of the sort has been cited as any sort of thing even approaching precedent. This hasn't happened before. It's wacky stuff. So again, I'm very optimistic, only slightly cautious. I'm much more optimistic for this case than I certainly was for Library. So anyway, we're going to have to wait a little bit longer, but we're about at that finish line, and just listen to Attorney Deaton here. You know, he's the legal guy. He's the attorney, not me. These would be positive outcomes by and large. Some of them exclusively positive, and some mostly positive, and some, even the ones that were the last one, you know, doesn't sound that positive, could still have a positive outcome. You know, if Attorney Deaton gets to jump in during the remedies portion and go for, you know, some sort of clarity for secondary markets sales. So you guys tell me what you think. I'll stop blabbering on, but I am feeling good about this. Very genuine. Just let me know what you think in the comments section below. Let's keep the conversation going. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.